All right, I'm ready on Priest. This is case number 95. Okay, this is case number 95-630-0003. The people of the state of Michigan versus Sean Taylor Priest. I don't even know what these codes mean. Ms. Ritter, what is the defendant charged with?
Judge, I believe it's 1 count of disorderly illegal occupant and then 2 counts of this alcohol disorderly person.
Okay. Today is a date set for pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning, Your Honor. D. Todd Williams appearing on behalf of Mr. Priest, P52845.
Okay. Can you have your client state his name, please?
Mr. Priest, you need to unmute your device, sir. Tap your screen and unmute your device, sir.
Unmute. There we go. All right, sorry about that. Sean Taylor Priest.
Thank you. Today is a date set for pretrial conference. Mr. Williams.
Yes, Your Honor. The last time we were here, it was my understanding that the prosecutor was going to research the case and see whether she had any witnesses left and make a decision on what she was going to do.
Ms. Ritter.
Well, Your Honor, due to the age of the case, the people were unable to locate the necessary witnesses and the necessary information to proceed on this matter. So at this time, Your Honor, we do not be able to proceed due to the extreme age of the case.
All right, Mr. Williams.
Yes, I'd make a motion to dismiss, Your Honor.
Today is a date set for pretrial conference. The people have indicated that they cannot locate their necessary witnesses and are unable to proceed. The court is going to therefore grant defense counsel's motion. The matter is dismissed without prejudice. Mr. Williams, if you could please, if you could submit an order of dismissal to my clerk, I will sign it and we will email it back to you. And then Mr. Priest, your lawyer can get you a copy for your records. Do you have my clerk's email address, Mr. Williams?
Your Honor, I don't believe I do, but if I could have it, I would appreciate it.
Mr. Flanagan, you're going to put it in the chat?
Yes, Your Honor. It's in the chat.
It's already in the chat, Mr. Williams.
That's fantastic, Judge. I appreciate it. Thank you, Mr. Flanagan.
All right, then we're all set. Mr. Priest, your lawyer will get you a copy of that order. Have a great day. Both of you stay safe.
Thank you, Judge. Appreciate that. You too.
All right, you're welcome. Good morning, Mr. Cripps.
Good morning, Your Honor. How are you?
I'm wonderful, thank you. How are you?
Good. Thank you, Judge.
We're ready on Tony. Did you need to speak with your client at all?
No, Your Honor.
All right, I'll bring them in.
Judge, actually, for Tony, can I have a couple minutes to talk to the complaining witness that's in person?
Oh, okay, yes.
Please.
Okay, so Mr. Cripps, give the prosecutor a couple of minutes.
Thank you, Your Honor.
All right. Good morning, Ms. Stevenson.
Good morning, Judge Bryant. How are you today?
I'm well, thank you.
Good.
There are 2 people in the waiting room with no plus signs. Did you all need to speak with them?
Let me just confirm those.
Oh, well, one of them not on the docket. Who was that? Let me see. Oh, no, yes, they are. Gibbs.
If the court is okay with Ms. Gibson's appearance, I'm fine with her.
Okay, because
yeah. Yeah, once you let her in, if you're okay with her, then I'm ready for her. And that's APA Moses's case, I think. Yes.
Okay, what about Ms. Isaac?
I think we need to talk with Ms. Isaac. Is that correct, Ms. Kirkland?
Yes, I have not spoken with Ms. Isaac.
Do you need, I'm assuming that this is Mr. Southern. Do you need Mr. Southern to go to the breakout room, or are you all set?
No, we need to talk to Mr. Southern, please, Your Honor.
Ms. Isaac, please accept to join the breakout room and wait for the lawyers to come in to speak with you.
Yes, ma'am.
Ms. Harris, please accept to join the breakout room and wait for the lawyers to come in to speak with you. All right, looks like we are ready on Tony. Ms. Tony, please start your video. Ms. Tony, please start your video. Oh, that's, okay. And please remove your hat. And please get stationary. Okay. All right, then we're ready on case number 236050901. The people of the state of Michigan versus Candace Sierra Tony. The defendant is charged with malicious destruction of property. Today is the date set for a final strike. Okay, well, it says pretrial conference, but it's at 9 o'clock. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I have the complainant witness present via Zoom this morning. Well, one of the complainant witnesses present via in person this morning. Miss I'm sorry, Judge. I'm drawing a blank. Miss Crawford, can you please state your name for the record?
Randy Crawford.
Okay, Mr. Cripps, your appearance, please.
Good morning, Your Honor. David Cripps, P34972, appearing on behalf of Candace Sierra Tony, who's joined us by Zoom.
Ms. Tony, please state your, you have to unmute first.
Sierra Tony.
And what's your
Sierra Tony.
Thank you. Today is the date set for a pretrial conference. Mr. Cripps, how do you wish to proceed?
Judge, my client was originally charged with a felony charge along with the count 2, the misdemeanor. At the preliminary examination, the complainant on counts 1 and 2 failed to appear. That'd be Celia Jones. So it was dismissed by Judge Jefferson without prejudice. However, because we only had a right to an exam on the felony charge, then a pretrial was set on your docket for the malicious destruction of property with the same complainant, Celia Jones.
Well, I'm confused because Ms. Ritter says that this person that's in the courtroom is the complaining witness on this count, Or,
Well, I understand that, but I'm going by what's in the charging document. And the document I have that was filed lists the complainant for the malicious destruction as Cecilia Jones.
Ms. Ritter?
Judge, so Mr. Cripps is correct. The complainant witness on the malicious destruction of property charge is Cecilia Jones. However, at the exam stage where the felony was dismissed and this case was brought in front of your honor, the people intended to, based off the testimony at the exam, the people intended to add a charge of assault and battery with this complainant witness, Ms. Crawford. So there will be an amendment to the count, to the complaint with the count 2 for assault and battery. But the malicious destruction of property complainant is not present.
Judge,
That sounds like a whole new case. What do you?
yeah.
That's, I mean, so, and if that was the case, why would you have not amended the complaint to present today at this pretrial conference?
Well, Judge, from my understanding, the charge was supposed to be amended at the felony exam stage. However, it has not. So it was upon myself to amend and add the charge of assault and battery to this count. Or this complaint, I'm sorry.
Judge, I'm in agreement with you. This would be a different complainant, a different charge. She'd have to be rearranged on new charge if the prosecutor's office sought to do that. Nobody ever mentioned to me at the exam that there was even a suggestion, because nobody, that there would be an amendment to anything. So we would ask for dismissal without prejudice, Your Honor.
Yeah, so, okay. So the people are, this is what I'm processing. The people are allowed to amend a complaint at any time up through and including on the day of trial. However, it seems to me, well, let me say this. However, there has to be a basis for the amendment that's clear on the record. So it appears to me that the amendment to add a count of assault or assault and battery should have occurred at the preliminary examination stage, because Judge Jefferson would have heard the testimony that would give rise to the amendment. Simply presenting a witness today without any charging document, without any record of what gives rise to the additional count, I don't think that that's appropriate or allowable based upon how the court rule reads. I think that would be now at this point an additional stage, an additional, I mean, it could have been an amendment. So let me say, it could have been an amendment had it been presented prior to today, but I can't give a pretrial conference on a case that doesn't even exist. So with respect to the malicious destruction of property, the complaining witness is not present. The complaining witness is not present. Now, even though it's scheduled at 9 o'clock, it seems like technically it's the first scheduling of the pretrial. However, that's the same complaining witness that did not appear at the final pretrial conference. I mean, I'm sorry, at the preliminary examination. Am I correct?
Yes, Your Honor.
All right. I am going to grant Mr. Cripps' request for a dismissal without prejudice on this charge. And then the people, it sounds like, though, Ms. Tony, it sounds like the people intend to charge you with assault or assault and battery as it relates to the person that's present in the courtroom today. And so just, you might have to look out for that. But as it relates to the malicious destruction of property, the court is going to dismiss the case without prejudice.
Thank you, Judge.
You're welcome. Anything further?
Not on
No,
behalf.
thank you, Your Honor.
All right, Mr. Cripps, if you could please submit the dismissal to Mr. Flanagan, I'll sign it.
Thank you, Your Honor.
All right.
Have a good day, everyone.
All right, you as well. Ready on Franklin.
Ready on Franklin, Your Honor.
Hello?
All right. This is case number 234559801, the People versus Trayvon Franklin. The defendant is charged with one count of assault or assault and battery. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson. Oh, I'm sorry about I didn't realize the complainant was right there. Sorry.
And I have the complainant witness present via Zoom this morning. Mr. Fulton, state your name for the record, please.
My name is Kenneth Fulton, Kenneth.
No, sir. No. State your name. State your name.
Kenneth Fulton.
Okay, thank you.
And I apologize, Your Honor, for the record, Janice Stevenson appearing on behalf of Trayvon Franklin. Mr. Franklin, sir, please unmute and say your full name.
Trayvon Franklin.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. On behalf of Mr. Franklin, we'll continue the plea of not guilty. We would ask that this matter be set for final pretrial conference. We would request discovery.
Court continues the not guilty plea. On behalf of Mr. Franklin, I will set the matter for a final pretrial conference. April the 23rd. At 9:00 a.m. Discovery should be submitted by March the 22nd. Bond will continue with no contact of any kind with the complaining witness. Mr. Fulton, you have appeared today, and therefore you are not required to appear on April the 23rd. However, you may appear, should you choose to, as the complaining witness, you may appear at all scheduled court appearances. Anything further with respect to Mr. Franklin?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Franklin. Thank you, Your Honor.
All right, then, gentlemen, we're all set. Have a great day and stay safe.
You too. Thank you.
You're welcome. Good morning, Ms. Moses.
Morning, Judge.
All right, looks like we're ready on Gibson. All right. This is case number 234409201, the people of the state of Michigan versus Monique Gibson. Defendant is charged with 1 count of child abuse, 4th degree, and today is the date set for a final pretrial conference. Appearances, please.
Thank you, Your Honor. Erica Moses on behalf of the people, P78491.
And for the records, Your Honor, Janice Stevenson appearing on behalf of Ms. Monique Gibson. Ms. Gibson, ma'am, please unmute and just say your full name.
Monique Alicia Gibson.
Thank you. Today is the date set for final pretrial conference. Ms. Stevenson.
Thank you, Your Honor. On behalf of Ms. Gibson, we'll continue the plea of not guilty and continue our demand for jury trial.
The court will continue a not guilty plea on behalf of Ms. Gibson. And what is the date of the jury trial? It's scheduled today for 19. Oh, I see it. Ms. Gibson is scheduled for jury trial on March the 5th at 10:30 a.m. And so we will continue the matter till the March 5th date.
Thank you, Judge.
Thank you, Your Honor.
Well, let me do this. Because Miss Moses, how old are your witnesses, or is your witness the complaining witness that's the subject of the child abuse?
Yes, she's still a minor child, Judge, but she's a teenager, not very young.
Okay. And then who has care, custody, and control over her?
That would be her mother.
Is Miss Gibson her mother?
No, Judge. This is a school incident, school bus incident.
So here's my question. You know, they like for us to have a final pretrial conference closer to the jury trial date, just so we can make sure that we still need those jurors. So do you have any issues? You were in contact with the complainant and her mother?
Yes, Judge. And on previous hearings in front of Your Honor, I believe the mother was present on Zoom, as well as her, I'm not sure if it's biological father or stepfather, but they are invested in the case. Yes, ma'am. Okay, so does everyone agree that you don't need a final pretrial conference? I was going to set it for March 1st, but if it's not needed, then we can just go ahead to the jury trial date. But understand that if I don't have a final pretrial conference on March 1st, and then we come on March 5th, and somebody is asking me for an adjournment for something that could have been addressed on March 1st, you're going to pay for the jury. Somebody has to pay for the jury. I'm not going to. So that would be the purpose of the March 1st date, in case there's some issue that we need to address. But is everybody comfortable with just coming March 5th?
On behalf of Ms. Gibson, we don't need another final pretrial.
Judge, and I would agree. If something were to come up, I'll contact the court before March 1st, but I don't anticipate any issues.
Okay, great. Then we will continue to the March 5th jury trial. And I'm assuming also, because I didn't receive any motions or anything, that with respect to that trial, it would just be the standard jury instructions. There are no requests for any special jury instructions, correct?
Not from the people, Judge.
On behalf of Ms. Gibson, Your Honor.
All right, then we're all set until March 5th. I'm assuming, I'm looking at my calendar for March 5th. I'm assuming that these other Wright and Kristen, they've already fallen off of that date, or are they were waiting to see what was going to happen on Gibson?
So Wright, I believe, may have fallen off. I'm not sure. The court wanted to wait for Mr. Gibson because the complaining witness did come to court for the final pretrial conference, and Sanders, the complaining witness was present, and Mr. Sanders had never missed court before, so the court did not want to cancel that date.
Okay, well, if they haven't fallen off, then just know that the March 5th date then will become a final pretrial unless I've set a different final pretrial, because Ms. Gibson's case is going and she is the first in priority on that day.
Okay.
All right, then we're all set. Everyone have a great day and stay safe.
Thank you, Your Honor. You too.
All right.
Thank you, Your Honor. Thanks, Ms.
And
Gibson.
that's at 10:30 in person. 10:30 in person.
Mm,
Oh, Ms. Stevenson, your client had her hand up. You want her to go back to breakout room?
Yes, please, Your Honor.
Okay, all right. Or go to breakout room, because she never Miss Moses, well, Miss Stevenson, you don't think it's something for the record, is it?
I don't think.
She said no. Okay, Miss Moses, you're all set. Have a great day. Stay. All right, Miss Gibson, accept to join that breakout room. You should have gotten a prompt. Yeah, I think she did. Okay. Miss Stevenson, let's do Stone before you go. I don't know.
Okay.
And then we can do some that Miss Kirkland is on while you talk to Miss Gibson.
Okay.
All right, this is case number 1646260, the People versus Crystal Star Stone. Defendant is charged with driving while license suspended, revoked, denied, second offense notice, operating with a high BAC, driver with an open intoxicant in a motor vehicle. Today is the date set for an arraignment, which is strange based on the year, but appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, appearing on behalf of Ms. Crystal Stone. Ms. Stone, ma'am, please say your full name.
Crystal Star Stone.
Mr. Flanagan, this is a first-time arraignment on this 2016 case?
Yes, Your Honor.
Okay, Ms. Stevenson?
Thank you, Your Honor. Ms. Stone does stand mute, waives the reading of the information, asks that a plea of not guilty be entered on her behalf and that the matter be set for pretrial conference.
Court will enter a not guilty plea on behalf of Ms. Stone, set the matter for pretrial conference. March the let's set it. Mr. Flanagan, how many do I have on March the 8th? Oh, I see. I have 13. I had 13 at the time I did this. Well, how many do I have on March 20th?
3.
I'm actually trying to keep that real light because I might be traveling. And we have a jury trial. So that's without the magistrates, of course. So that's probably 13. What about the 19th? Let's go March 19th. How many do I have?
5.
And that is, yeah. You said 5 and all of them jury trials. I only have 4 jury trials that day. What?
Bolden, Bray.
Wait a minute, say it again. Hold on. You said who?
Bolden.
I don't have a Bolden. Who is Bolden?
Khalid Bolden.
I don't have that on my list. Who's the lawyer?
Ms. Stevens, our MFD. They were last here March 24th of last year. Their final pretrial.
Well, first of all, that's not the truth. If they were only here March of last year, they don't have a jury trial date. That is wrong. Who put, that is wrong. If the last time they appeared before me was March of last year, they do not have a March jury trial date. Ms. Stevenson, what do you have for Bolden?
I don't have anything with me right now, Judge, on
No,
Bolden.
it's not. That's wrong. Send me that registered. That's wrong. That's not right. That's incorrect. So then you should have, the only jury trials I have on my schedule for March 19th are Willie Brake, the Paluk jury trial left because that was dismissed. Then I have McCutcheon and Okoro. I only have 3 jury trials on my docket. What's the other jury trial that you have?
Crystal Jordan.
I don't have a Crystal Jordan.
I'll send you this record too.
That's not right. Who's the lawyer on Crystal Jordan?
That's me. I have that on that's the 19th of March we're talking about?
Yes.
I have that.
For jury trial?
Yes.
No, that's not. Okay. When is the final pretrial conference?
March 1st, I think.
Yes.
Okay, I'm gonna put it down, but that's not. Oh, did I just add that?
Recently.
Okay, yeah, maybe I added to replace the other one. Okay, so then I should only have 4 cases then. All right, so I'm gonna set Ms. Stone for a pretrial conference March 19th. And that's gonna be at 8:29. I'm sorry, 8:25, excuse me. And if the people could get the discovery to Ms. Stevenson before that date, preferably by March 1st. Bond will continue, and then Ms. Stone, hold on. Even though the case is from 2016, I am going to order once a month urinalysis as a condition of the bond. No drinking and no driving without a valid license. And she will submit to urinalysis once a month as a condition of her bond. She is current in court now, so she could go across to probation and set up that urinalysis today. Anything further?
No, thank you, Your Honor.
Judge, I don't think a bond has been set.
Oh, today is arraignment. Thank you, Ms. Stevenson Esteban.
I'm asking for personal bond, Your Honor. I do have good contact information for Ms. Stone. I believe she's included, or she has tendered an advice rights form with that current contact information. She's here in person, ready to take care of this matter from 2016, I believe. I'm asking for personal bond, and Ms. Stone appears to have a question, which I would like to address outside the hearing of the court, if the court would allow me to enter the courtroom.
You may.
Thank you. Thank you, Your Honor.
All right, anything further?
Your Honor, so Ms. Stone has advised me that this is with regard to the court date that has been set, Your Honor. Ms. Stone has advised me that at the time of this incident, there were some bond conditions that were set. I don't have any information about that, Your Honor, which lead Ms. Stone to believe that she may have already complied with all of the conditions that this court has ordered. In addition, Ms.
Stevenson, I'm not going to address that. Mr. Flanagan has indicated to this court that as it relates to Ms. Stone and this case, that this is a first-time arraignment. Unless you have some information that is official from the court that says this is not a first-time arraignment, I don't want to hear about her thinking she complied with some conditions. She might have had a different case. Mr. Flanagan has indicated this is a first-time arraignment. So if you're going to look at the register and tell me that that is not a first-time arraignment, then I'll entertain. Otherwise, I'm not going to entertain that.
Which I won't be offering that, Your Honor. Ms. Stone further, Your Honor, is asking the court if there's any way that she can have an earlier first pretrial conference date. She learned that this warrant was outstanding in the course of a background check. She has a very, very, very good job waiting for the resolution of this matter, Your Honor, and is asking for her.
What is it going to do if she gets an earlier date? What is that going to do? If I give her an earlier date and you don't have discovery and we come here, how's that going to help?
I understand the court's concern, Your Honor. I'm only expressing my client's desires. That's what she wants the court to do.
Yeah, well, I'm going to express that. Sometime when your client tells you stuff, you should say, we can't do that because this is why. And then, no, I'm not going to ask the judge that because she's going to say no, because why would we come here if we don't have discovery? And unless you're going to just go ahead and plead guilty today with no offer, that's the only thing that's going to give her a quicker resolution. So again, no, I've already given her a March date instead of an April date. I've been giving out April dates. And so I gave her a March date instead of an April date so that we can try to resolve the matter. So the answer to that also is no.
Thank you, Your Honor.
All right, anything further?
And finally, Judge, it looks like a bond may in fact have been posted on this case, which we would ask be continued. It looks like there was a $10 bond that was posted there. So I'd ask that bond be set at $100, 10%, and that bond be continued.
Any response from the people?
Does the people have no objection with continuing bond? We're just asking for the court to just keep the random urinalysis testing for once a month.
All right, so the $100 10% bond that was posted will continue. That also lets the court know that even though this is allegedly a first-time arraignment, okay, that she missed court, because I'm the only one that sets $100 10% bonds. I'm the only one that set $100 10% bond. The magistrate was never going to set $100 10% bond. So the bond will continue, and the urinalysis will be added.
Okay. With that, I don't think we have anything further at this time, Your Honor.
All right, then you're all set. Have a great day. Stay safe.
Thank you, Your Honor.
All right, are we ready on Isaac?
Yes, Your Honor.
Okay, Ms. Isaac, sit up straight for me.
thought I was sitting up straight. Yes, ma'am.
You didn't think you were sitting up straight because you were clearly leaning forward.
That is correct, ma'am.
It is. It is correct. Ms. Jefferson, start your video, please. Okay, Ms. Jefferson, you might want to adjust your video because you got stuff going on your table that I'm not sure you want me to see.
I'm at work. It's a puzzle, but I'm moving it out the way.
Okay, listen, why are you late for court, ma'am?
I wasn't late. My video had ended and I came back. I had already talked to my attorney and everything, and she told me to read a break for the judge to join this video.
Okay, thank you. So can somebody put a plus sign by her name then?
Yes, doing that now.
All right. Well, I could tell you that if she was here, she came real early and left real early because I don't have her name highlighted on my document, but I'm going to highlight it now. And I'm ready on Isaac. This is case number 184570201, the People versus Tiffany Isaac. The defendant is charged with 1 count of assault and battery and 1 count of disorderly disturbance. And today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Kashava Kirkland on behalf of Miss Isaac, P84015. Miss Isaac, can you please state your name for the record? Unmute yourself.
Sorry, thought I did. Tiffany Isaac.
Today is the date set for a pretrial conference. Miss Kirkland, how are you proceeding?
Your Honor, we move for dismissal in the absence of the complainant.
Ms. Ritter.
Judge, I don't see the complainant witness, Ms. Tanika Barber, in the waiting room. However, it's the first time pretrial conference. I respectfully ask the court to adjourn the pretrial conference and give the complainant witness one more opportunity to appear.
Today is the day set for pretrial conference. It's scheduled as a first-time pretrial, but the case number says that perhaps some time ago they may have had a previous one. I don't know, but nonetheless, the court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm going to set a pretrial conference for February the Mr. Flanagan, how many do I have on February the 21st or 22nd?
$19 on February 21st. $26 on February 22nd.
On both of those days, have the magistrates already put cases on?
Yes, Your Honor.
All right, so I'm going to put it on February 21st because one of these jury trials that's still listed is not going to go. Therefore, I will have one less case on February 21st. So let's put it on February 21st at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further with respect to Ms. Isaac?
No,
Your Honor, thank you.
All right, Ms. Isaac, you're all set until February 21st, ma'am, at 8:36. Have a great day. Stay safe.
Yes, ma'am. Thank you.
You're welcome. All right, I'm ready on Jefferson. This is case number 224488501, the people of the state of Michigan versus India Danae Jefferson. The defendant is charged with 1 count of malicious destruction of property. Today is the date set for pre-trial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Kashava Kirkland on behalf of Ms. Jefferson, P84015. Ms. Jefferson, please state your name for the record.
India Jefferson.
Thank you. Today is the date set for pre-trial conference. How are we proceeding?
Your Honor, defense will move for dismissal in the absence of the complainant.
Ms. Ritter.
Your Honor, I don't see the complainant witness, Ms. Shantae Chambers, in the waiting room. However, it's scheduled as a first-time pretrial conference. I respectfully ask the court to adjourn the pretrial conference and give the complainant witness one more opportunity to appear.
Today is the day set for pretrial conference. It is a first-time pretrial conference. The court is going to deny defense counsel's motion to dismiss, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I am going to set the matter for February the 22nd at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant did not appear or should not be required to appear. Bond will continue with no contact with the complainant. Anything further with respect to Ms. Jefferson?
Nothing from defense, Your Honor. Thank you.
All right, Ms. Jefferson, then you're all set until February 22nd, ma'am, at 8:36. Have a great day. Stay safe.
Thank you.
You're welcome. I'm ready on Anderson. This is case number 194523301. The people of the state of Michigan versus Letitia. Could be Sharnice, middle name, but it's cut off. And then Anderson. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Kashava Kirkland on behalf of Ms. Anderson, P84015. Ms. Anderson, please unmute yourself and state your name for the record.
Good morning. My name is Leticia Anderson.
What's your full name?
Leticia Shantae Anderson.
Spell Shantae for me.
SHANTAE.
Mr. Flanagan, what middle name do you have on this? This doesn't say Shantae.
No, Your Honor, it says like Sharntae, SHARNTAE.
Oh, they put a R in there. That shouldn't be. Is that what's listed on the complaint with an R?
Yes, but the AKA, Your Honor, is SHANTAE.
That's a shame how they just give a person an AKA when they misspell the name. Put that AKA as the first name. Put that first. They messed up the spelling. You know, that messes people up when they're trying to check their record. That misspelling messes them up. And then that's how sometimes they say they didn't know the thing was there because the prosecutor's office misspelled their name. Ms. Ritter. All right, so it's no R. All right, today is the day set for pretrial, and I'm sorry, how are we proceeding, Ms. Kirkland?
Your Honor, we will move for dismissal in the absence of the complainant.
Ms. Ritter.
Judge, I don't see the complainant witness, Ms. Latidra Fisher, in the waiting room. It's scheduled as a first-time pretrial conference, Judge, and it's from 2019. I'll respectfully ask the court to adjourn a pretrial conference and see if the people can locate the complainant witness to see how we will move forward.
Court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm going to set the matter for February 27th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness did not appear, or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
No, Your Honor, thank you.
All right, then, Ms. Anderson, you're all set until February 27th at 9:00 a.m. Have a great day and stay safe.
Thank you, Your Honor.
You're welcome. All right, I don't have some people highlighted. Let's see. All right, are we ready on Morgan, Williams, and Harris?
Yes to Morgan and Williams, Your Honor. Harris. If we could just save Harris for last, but I'm already on Morgan and Williams.
Mr. Flanagan, did you already perhaps send me a register on Morgan? It's on arraignment on a bench warrant. Is it a review or just a, I shouldn't say a review. Is it scheduled for, is it in the pre-trial stages or the post-trial stages?
Post-trial, Your Honor. I'll send you the ROA in the order.
Who's the complaining? What's going on in my brain today? Who's the probation officer?
Bumpus.
See if she has a review for that. Let me see.
Okay.
Well, let me see if she sent me one because I didn't check. So let me see. No, she didn't send me one. See if she has a review for that.
Okay.
All right. Okay, this is case number 23-455-9701, the People versus DeLorean John Williams. Defendant is charged with assault or assault and battery. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Kashava Kirkland on behalf of Mr. Williams, P84015. Mr. Williams, please unmute yourself and state your name for the record.
DeLorean Williams.
Mr. Williams, what's your middle name, please?
John Terry.
Thank you so much. Today is the date set for pretrial conference. Ms. Kirkland, how are we proceeding?
Your Honor, we would move for dismissal in the absence of the complainant.
Ms. Ritter.
Your Honor, I don't see the complaining witness, Anita Williams, in the waiting room. However, and for the court's information, Judge, the complaining witness is the mother of defendant, Mr. Williams. However, Judge, it's the first time pretrial conference. I respectfully ask the court to adjourn the pretrial conference and give Ms. Williams one more opportunity to appear, noting that if she does appear, that this may qualify as a transfer to courtroom 338.
It qualifies right now as a transfer. Mr. Flanagan, call next door and see what date they want me to give Mr. Williams for a return pretrial conference where the complainant has to appear.
Yes, ma'am. Okay, Your Honor, February 6th at 8:30.
They don't be holding us up. They feel like they could reach the complainant that quick. Okay, I mean, I'm not gonna mind nobody's business but my own. February 6th at 8:30. Mr. Williams, when you logged into the court today, did you type in the Zoom ID number or did you go to the website and click on the link?
I typed in the Zoom ID number.
And do you have that Zoom ID number nearby?
Yes.
Okay. Look at that Zoom ID number, Mr. Williams, and where you see that 9, change it to an 8 and log into Judge Garrett's courtroom on February 6th. So it's everything except change that 9 to an 8, okay?
Okay.
All right.
And
Anything
you said
further?
February 6th?
Yes, February 6th at 8:30.
Okay.
All right. Anything further?
Judge, is the complainant witness required to appear for Judge Garrett on that day? Nothing further from the people, Judge. Thank you.
All right.
Nothing from defense, Your Honor. Thank you.
Mr. Williams, you're all set, sir. Have a great day. Stay safe.
You too. Thank you.
Oh, Mr. Flanagan, that message in the chat, that's with respect to the lady that was in person?
Yes, Your Honor.
Oh, yeah. Okay. I knew she had missed something. All right. All right. Oh, what did Ms. Bumpus say?
I couldn't get a hold of her. I'll call right back.
Don't worry. I'll just have to have them come back. Did you send me the register?
Sending right now.
Okay. Then let's go ahead and do Harris and then Southern, and then I'll look at the register for Morgan. Does anyone know the person who just came in the?
My name is Danya Harris.
No, ma'am. No, I didn't ask you for your name. Thank you so much. Does anyone know the person who just came into the waiting room?
That's Mr. Ross Springer. I'll change the name at 10.
Okay, thank you.
All right, my bad.
All right, Ms. Ritter, you turned off your camera. I'm ready.
I'm ready, Judge. I'm blowing my nose.
Oh, well, you didn't have to tell us. You ain't have to tell us. You just could have said, okay, Judge, I'm ready. Did y'all see? The young lawyers, I love them. All right, this is case number 234460501. The people of the state of Michigan versus Danya Harris. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Danya Harris. Ms. Harris, ma'am, please unmute and just say your full name.
Danya Harris.
Today is the date set for final pretrial conference. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. Ms. Harris continues her plea of not guilty and continues her jury demand to the February 26th jury trial date.
The court is going to continue a not guilty plea on behalf of Ms. Harris and continue the matter to jury trial. I don't know, am I in the right book? Okay. So let's go to these other cases. What happened to, Ms. Gibson is going. Didn't we just do Ms. Wait a minute, why do I have Ms. Gibson on 2 days? What's Ms. Gibson's trial date?
3/5.
Why did I have her on 2/26 also? That's weird. Okay. So Ms. Gibson is not even supposed to be on that day. I must have changed it because I didn't just write that. All right. And then what happened to Hearn? They had a final pretrial conference on January 5th.
I think that trial date fell off.
Mr. Flanagan?
Yes, Your Honor. They're not on the docket anymore, February 26th.
We don't know what happened to him, though,
Let me see.
He didn't make his final pretrial.
huh? Oh, so he was capious.
Yes.
Okay.
Terry,
So
Mr. Flanagan.
with respect to Ms. Harris, then the court is going to continue a not guilty plea on behalf of Ms. Harris and continue the matter to jury trial February 26th at 10:30 a.m. Anything with respect to that trial date? Any issues or anything that the court needs to be aware of?
Not from the judge.
None on behalf of Ms. Harris, Your Honor.
All right, then we're all set until February the 26th at 10:30 a.m. at 36th District Court in person. Make sure we are properly attired for court, no ripped jeans, no, just send your client a copy of the dress code policy. All right.
Yes, sure.
All right, then we're all set. Have a great day. Stay safe. Jury trial, February 26th. Oh, shoot, I didn't mean to do that. All right, I'm ready on Southern. These are case numbers 234482601, 234482801, 234512101, 234512301, the people of the state of Michigan versus Eugene Lewis. Southern defendant is charged in each case with 1 count of retail fraud. And for each case, today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. And Judge, did the court call case number ending in 590?
I don't have a 590 on my docket. But if that's the case from yesterday, then that one too. Can we finish with appearances, please?
For the record, Your Honor, Janice Stevenson appearing on behalf of Eugene Southern. Mr. Southern, sir, please say your full name.
Eugene Louis Southern.
Today is the date set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Southern and I have had the opportunity to discuss these matters, and we've had the opportunity to confer with the people. At this time, Your Honor, Mr. Southern does wish to avail himself of an offer from the people. He wishes to offer the court a plea of guilty as charged in case number 2304482801. I'm sorry, please, I stand corrected. He wishes to offer the court a plea of guilty as charged in case number 2304559001. We believe he's charged with retail fraud in that matter, and he does wish to waive his rights incident trial and offer the court a plea of guilty as charged in case number 23045120 301. We believe he's charged with retail fraud second degree in that matter. Is pursuant to plea agreement with the people, Your Honor, wherein we believe the remaining matters called by the court would be dismissed.
Ms. Ritter?
Judge, that is correct. The people's offer is for Mr. Southern to plead guilty as charged to case number 230-455-9001 and 230-451-2301. In exchange, the people will dismiss case number 230-448-2601, 230-448-2801, and 230-451-2101.
Mr. Southern, you've heard the offer from the people with respect to your cases. Is it your desire to accept that offer, sir?
Yes, ma'am.
Mr. Southern, I'm going to share the screen. I'm going to share my screen. On my screen will appear, excuse me. Okay, let me pull it up. All right, on my screen is going to appear an advice of rights form. My question to you, Mr. Southern, is have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, I've seen it.
When you did that, did you understand your constitutional rights, Mr. Southern?
Yes, I did.
Sir, do you understand that these are misdemeanors and therefore you do have a right to a trial as to each of these cases? However, if I accept your guilty plea today, you will be giving up your right to a trial. Do you understand that?
Yes, I do.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to enter into this plea?
No.
And are you currently on probation or parole?
No.
Finally, sir, drawing your attention to number 11 of the advice of rights form. Do you understand, Mr. Southern, that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to request permission of this court to set aside your guilty plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes, I do.
With that understanding, Mr. Southern, do you still want to give up your rights to a trial and enter into it today?
Yes.
Raise your right hand for me. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Ms. Stevenson.
Thank you very much, Your Honor. Mr. Southern, I am going to draw your attention to the date of August 20th, 2023. Mr. Southern, on that date, were you present at 1385 East 8 Mile Road in the city of Detroit, commonly known as Marshall's Stores?
Yes.
Was Marshall's open to the public on that date when you were there?
Yes.
And did you attempt to leave the store with merchandise which Marshall's was offering for sale without paying for that merchandise?
Yes.
Thank you. And then I would, should I do both of them or just finish them one at a time, Judge?
No, both.
And then I would draw your attention to August 22nd, 2023, Mr. Southern. Were you again present at 1385 East 8 Mile Road in the city of Detroit, commonly known as Marshall's Stores?
Yes.
And was Marshall's open to the public while you were there?
Yes.
And did you attempt to leave the store with merchandise Marshall's was offering for sale without paying for that merchandise?
Yes.
And did the value of that merchandise exceed $200 but less than $1,000?
Yes.
Thank you. With that, Your Honor, defense is satisfied.
Are the people satisfied?
No, Judge. The people are not satisfied only because the amount was less than 200. It's retail fraud in the second degree. So it was not more than 200, it was less than 200.
For both of the cases? You're saying for both of the cases?
Well, for one of the cases, it was less than 200. The other case, it was less than 100.
Okay. So,
Mr. Southern, prior to August 22nd of 2023, had you been previously convicted of retail fraud?
Yes.
Thank you. With that, Your Honor, defense is satisfied. Thank you for that correction, Madam Prosecutor.
I don't think that's the correction she made, Ms. Stevenson. I think
So,
she's saying you asked Mr. Southern what's the value of the property between 200 and 500 or something. You asked him, was it more than $200 but less than some other amount? Ms. Ritter is saying the value of the property on the charge that he's pleading to, both of the values of the property were less than $200.
right. And so the charge on the August 22nd case is retail fraud second degree, which would mean that the only way they could charge him with that is because of a prior conviction, if the value was less than $200.
Right, you didn't say that though, Ms. Stevenson.
No, I did. I just asked in the follow-up whether or not prior to August 22nd, 2023, if Mr. Southern had been previously convicted of retail fraud.
But you also didn't ask him if the value of the property was less than $200.
Mr. Southern, when you were in Marshall's on August 22nd of 2023,
Or
did
you
you
could
attempt?
stipulate to it. I mean, I don't, either way, but I'm just saying that was the correction she made.
Did you attempt to leave the store with merchandise that was offered for sale valued at less than $200, Mr. Southern?
Yes, ma'am.
Your Honor, with that, defense is satisfied. My apologies to the court.
That's okay. Are the people satisfied?
The people are not satisfied. Thank you, Judge.
Okay, and the court is satisfied, and I will accept a guilty plea to 2 counts of retail fraud in second degree as to cases ending in 5590 and 5123. With respect to the remaining cases, the court is going to dismiss the remaining cases ending in 4826, 4828, 5121, and 0509. Having accepted that guilty plea, those guilty pleas, is there any objection to immediate sentencing for Mr. Southern? I do understand that Marshall's was present yesterday. They're not present today. And so, Ms. Ritter, is there an objection to proceeding without giving Marshall's an opportunity to speak?
Judge, Marshall's was, well, first Judge, just a correction for the record, the court stated that they're dismissing case number ending 0509. That wasn't Mr. Southern's case, that was Ms. Thompson. And then
I didn't mean it. Okay, yes, thank you. I don't know. I highlighted the wrong one. I'm sorry. Thank you.
It's okay, Judge. I just want a clear record. With respect to Marshall's, Judge, only because this is a repeated offense against the same store, I would like to give Marshall an opportunity to make a victim impact statement. So I'm going to object to the immediate sentencing at this time.
Okay. So when is Mr. Southern's next court date on that circuit court case?
I believe, let me pull the email up, Judge. I know it's sometime early February.
Okay. And then also, how long has he been in custody now?
Mr. Southern has been continuously incarcerated at the Wayne County Jail since, I believe, August 23rd, according to information Deputy just provided me this morning. And the retail fraud second degrees, those are both 93-day misdemeanors? Or are they 1 year? Second is 1 year. Okay.
And Judge, his next court date on the felony matter is February 2nd.
Okay, so then let's do this so I'll know, if they do whatever resolution they're doing, now they could take into consideration that he's already pled to these two. They could take that into consideration on the felony. But so let's bring him in February okay, so that's February 2nd. Let's bring them in February the 7th. Give the people an opportunity to reach out to no, it's not Myers. Marshall's. and see if they want to come in and make a statement to the court. Mr. Southern, you have a right to be brought over to court for your sentencing, to be sentenced in person. You can also consent to being sentenced on Zoom. What do you prefer, Mr. Southern?
Sentencing on Zoom.
Okay, then we're gonna set it for, I'm gonna put it on the docket for 8:59. So I know I didn't order a pre-sentence report. I'm not gonna order one. He's been in custody long enough for me not to order one. Because there's a 99.9% chance that I'm gonna give him some jail time with credit for time served. But the victim does have a right to make an impact statement. Unless we come, well, even if he comes back, and I mean, I guess the only thing that might change it is if something happens and he's gonna be going home on the felony, then I might consider probation, but with that theft awareness class. But that's you know, a slim possibility. Okay.
Okay.
All right. So did Mr. Southern say something? No. Okay. All right. Anything further then with respect to this case?
What was the sentencing date again, Judge? I'm sorry.
February 7th.
Okay, nothing further, Judge. Thank you.
Your Honor, on behalf of Mr. Southern, if it is, there have been some discussion about possibly requesting restitution in this matter. Could we also consider the February 7th date of an ability to pay hearing if restitution were to be ordered?
Yes.
Thank you, Your Honor.
So that means he is alleged that he actually left the store and they did not retrieve the items?
That's correct, Judge.
Oh, okay. Yeah, we'll set that. And that may also depend on the status of his circuit court case too. In terms of the ability to pay, yeah. Okay, then we're all set until February 7th. Have a great day despite where you are, Mr. Southern. Stay safe.
Thank you. You too.
All right.
Thank you, Your Honor.
You're welcome. Ms. Stevenson, I did send you emails for the reviews while we've been continuing on. I think we are ready on Samuel.
Okay.
And you probably need to speak to Ross Springer. Mr. Ross Springer, start your camera. I'm going to send you to a breakout room, Mr. Ross Springer. I'll turn your camera around because you sideways. Okay, there you go. All right, I'm going to send you to a breakout room. Except to join the breakout room, the lawyers will come in to speak with you shortly. And then, but for him, this is his first review anyway.
Are you okay with him the way he was? I would like to bring him right back out.
I guess so.
Okay.
If you are okay. Yeah. All right. So I'm assuming that the person sitting on the, boy, these people coming in my docket. Oh, I didn't bring in Miss Carnarvon. We had a report or something for her for last time. All right, let me bring in this unidentified. And the individual that was just let into the Zoom room, please unmute and state your name. Can the individual that was just let into the Zoom room, please unmute and state your name? Can the individual that was just let into the Zoom room please unmute your device and state your name? All right, I'm going to remove that device. I'll bring in Ms. Carnarvon. Okay, I don't know why she's not connecting, but are you ready on? Are you ready on Morgan?
Ready
Wait.
on Morgan, Your Honor. Oh,
Morgan, oh yes, are you ready on Morgan?
yes, I'm ready on Mr. Morgan, Your Honor.
That's probably because she wasn't sitting at that device. That's what that was about. All right, this is case number 146561202, the people versus George Heflin Morgan. The defendant is charged with 1 count of assault or assault and battery. Strike that, 2 counts of assault or assault and battery. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. George Morgan. Mr. Morgan, sir, please unmute and say your full name.
George Heflin Morgan.
Today is the date set for an arraignment on a bench warrant. As to the arraignment on the bench warrant, Mr. Flanagan, I thought you had sent me this. Oh yeah, it's right here. Okay. How are we proceeding?
On behalf of Mr. Morgan, Your Honor, I'm going to ask the court to give Mr. Morgan an opportunity to bring this probation into compliance.
As to the arraignment on the bench warrant, Ms. Stevens.
Oh, I'm sorry, standing mute, waives reading of the information as to the plea of not guilty in Trina's behalf, and that we move to get the matter scheduled for review, Your Honor.
Court will enter a not guilty plea as to the arraignment on the bench warrant. And as to the request to give him an opportunity to get the matter back on track, Mr. Morgan was sentenced either on October 25th or on November 25th, but I don't know. His signature is dated November 25th, but the order is dated October 25th. And that's 2019. He had a lot of capiases in here. It's a lot. It's just a lot of capiases. A lot. And then, so it looks like he was sentenced in October. It looks like you were his lawyer too. And then he was scheduled for review. Well, the final review was October of 2020. That whole year was going by with no interim review dates. He was placed on probation for 18 months according to the register, but I need to scroll back up. He was ordered to do many things, and then it looks like he had some probation report days. And I don't know if he appeared or not, but he was having some probation report days. And then when it was time for the review, he failed to appear. After the 1 year, he failed to appear. And then he did appear, or at least looks like he was scheduled by the magistrates or something or other. Let's see, he failed to appear November 20th. And then I set it for review February the 3rd of 2021. February 3rd, 2021, he failed to appear. And then I think he didn't reappear until now, until he was arraigned on the bench warrant. Now, why would I give him a chance to come into compliance?
Your Honor, I've had an opportunity to talk with Mr. Morgan. I do remember his trial. I remember his trial before this court, Your Honor.
Before me? You didn't remember his trial before me?
Yes, I do.
Why do you remember his trial before me? Because his sentencing order is signed by Judge Kenneth King.
And I'm not sure how we got to that place, but I do remember doing this trial before this court.
What was the trial about? That's not matching up, Ms. Stevenson.
So,
let's see.
June 12th, 2018.
I wasn't on the docket. What are you talking about? Let me see. I wasn't on this docket. Well, hold on. 2018. I mean, am I looking at the wrong? Hold on. Who is this up here? Oh, wait. Maybe I'm looking. Mr. Flanagan, you might have sent me the wrong thing. Hold on. Oh, maybe I'm looking at the wrong thing. Hold on. I'm looking at the wrong thing. So hold on. Let me click this off. No, I'm not looking at the wrong thing. This is okay. Okay. What date are you looking at?
I think it was June 12th, 2018.
Okay, let me go to that. June 12th. Oh, this might have been, okay. This is weird. This may have been when I received all that work I was overloaded with when I was doing the domestic violence docket and the assault portion of the misdemeanor docket. So it looks like I did do a trial on this case, and then it was scheduled for sentencing. He must have failed to appear at the sentencing, August 20th, 2018. Now, I don't remember the trial. Let me just be clear about that. But he was scheduled for sentencing August the 20th, 2018. And he failed to appear. And that's how Judge King ended up sentencing him, because when he did appear, then Judge King was handling the cases.
Yes.
Okay.
So I wasn't really sure how it didn't end up with Judge Garrett instead of going to Judge King, but Mr.
Because it
Morgan
wasn't a domestic violence case. Was it a domestic violence case?
No, it was on that combined docket. But
right. Yeah.
Mr. Morgan was sentenced by Judge King. And the reason I just remember a lot of complexities of Mr. Morgan's life and with his family and all that, Your Honor. So those issues have just continued to plague Mr. Morgan, which is the reason it took so long for him to get sentenced. And then with him coming back in after we got into the middle of COVID, trying to get the case back on track, looks like Mr. Morgan just continued to struggle. But I did have an opportunity very briefly to hear while I was in the breakout room that at this point, it looks like Mr. Morgan has some support at this time. And I think that will help him to try to finally get this case, which I think happened like in 2015 or 14, Your Honor, to actually get this case totally put behind him. I've given Mr. Morgan in 2014, I gave Mr. Morgan some contact information for anger management facilities that are approved by this court, first EVA and then the care if Mr. Rice just has too many people right now. I think that Mr. Morgan could absolutely benefit from the guidance of Ms. Bumpus at 36 District Court probation. I think he could benefit from a course of anger management. I see that he does have some support now, Your Honor, just to try to help him manage this probation, even though ultimately, if he doesn't do what he's supposed to do, I think he got convicted of 2 counts of assault and battery. So, you know, I don't want him to go to jail for 6 months. He doesn't want to go to jail for 6 months or a day, if that can at all be avoided. And I would ask the court for those reasons to give Mr. Morgan an opportunity to get the probation back on track.
Ms. Stevenson, I don't know what you mean by he now has support, but that doesn't mean anything to me because people have to do what they're supposed to do, whether they have support or not. You know, I mean, I want some support. I want some support. I want somebody to help me with all the stuff that I have to do. And this is not support. It's sometimes you just don't get support. And when you don't get support, you just have to show up and do what you're supposed to do, or you might go to jail. So listen, because if not having support is an acceptable reason for you, if I'm saying, oh yeah, I understand, because he didn't have support, I understand, therefore he couldn't, you know, he get a pass. That means his support controls whether he is successful on probation or not. That means his support determines whether he goes to jail or not. His support shouldn't have that much control over his life. Whether you support me or not, I'm going to show up every day and do what I need to do. And some days it's going to be extremely, extremely difficult. But with or without support, I'm going to do what is necessary to keep myself out of jail. I don't remember the trial. I don't remember anything about Mr. Morgan, because I'm sure I've done, you know, I almost want to say 1,000 trials since then, but maybe the docket wasn't that that heavy. I feel like I've done 5,000 trials. So I'm going to reinstate the probation, but this the last, like, he has so many capiases. He has so many, I don't have support, so I ain't showing up days. And we just don't have the luxury. We just don't have the luxury of that. So, okay, we're going to reinstate Mr. Morgan's probation. Give him a chance to work with Miss McComb. Or Miss Bumpus. And I mean, I don't really care about his support. I care about, you know, him giving us a chance, this court a chance to support him. That's the support he needs. You don't need whatever support he has, that's good. But if they wake up tomorrow and say they don't want to support him, Mr. Morgan has to continue to do what he's supposed to do. All right. So it looks like, I mean, he had some probation report days that I see on the register. I don't know. I mean, I suppose they wouldn't just keep scheduling them. I don't know how that works, but what I'll do is reinstate it. I'll reinstate them for 6 months. And then I'll reinstate it for 6 months, which would put us in let's say July the 23rd. July 23rd, that's the 6-month date. And we'll put a, review time for 10 o'clock. And then I'm going to give them a review for 3 months. So that'll be April the 20, let's see. Yeah, April 25th at 1:30. And all of his conditions that were originally set by Judge King are instituted. I'm just reinstating the probation as is. Anything further?
I have nothing further on behalf of Mr. Morgan at this time. Thank you very much, Your Honor.
All right, Mr. Morgan. I'm happy that you have support now. I am, but I hope you were listening to me. You can't just rely on your support. You gotta do this probation, okay?
Okay.
All right, I'll see you in April, okay?
All right. Thank
Have
you.
a great day. You're welcome. Stay safe.
Thank you, Your Honor.
You're welcome. All right, I'm ready on Samuel. Case number, let me let him get up to the podium first. Case number 146122201. The People versus Antoine Lamont Samuel. The defendant is charged with operating while intoxicated. Today is the date set for review. Ms. Stevens, for appearance, please.
Janice Stevenson on behalf of Mr. Antoine Samuel. Good morning, Mr. Samuel, sir. Please tell the judge your full name.
Good morning, Antoine Lamont Samuel.
Thank you. Today is the date set for review. Mr. Samuel was placed on probation for 9 months, and this is his first review date. But it looks like he was placed on probation in August, and so this should be his midway point. 5 months in. He has completed all the terms and conditions of his probation. He looks like he was trying to get off probation early. You were trying to get off probation early, Mr. Samuel?
Yes, ma'am. That's your honor.
Mr. Samuel, you saying you were like, I'm not gonna go see her for no 9 months. That's what you were saying?
Yes.
I don't take it personally, Mr. Samuel. I don't take it personally. Ms. Stevenson.
Your Honor, I'm going to move that the matter be closed with improvement. Thanking Mr. Samuel for a job well done.
Job well done. You did a great job. Mr. Flanagan, can you look at the probation order? Do you have his probation order?
Yes, Your Honor.
How much did I charge him for the oversight fees?
$420.
That was too much. Who said that? He was only on for 9. It says $420
For supervision fees? Yes.
That's a mistake. I'm gonna just let y'all know. Whoever put that in, that's not the truth, because he's only on probation for 9 months. So it should have been 9 times 35. it should only have been $315. So he paid $1,200. Now I need to see everything his fines, costs, and fees totaled $1,200 that he paid. So can you give me a rundown then of what he paid? Because we definitely have to give him a refund, but it looks like I have to give him more than I thought I was going to have to give. So how much was his fine?
The fine.
Dude, can you just scan it to me right quick? Let me see.
Oh, yes.
So, Mr. Samuel, obviously, I'm going to discharge you early. You did a great job. Congratulations. But I was going to just refund half of the oversight fees, but I may owe you some more money. So I just need to look. I mean, not me. I don't owe you any money, but the court. The court owes you some money. So as soon as he scans that to me, I'll let you know how much your refund is going to be.
Okay.
Mr. Cunningham, start your camera for me. Oh, good morning, Mr. Cunningham. What time did you think you were supposed to be in court today? Mr. Cunningham, it appears that you don't have on a shirt. I'm going to put you back in the waiting room to let you get dressed for court. Get dressed for court and I'll bring you back out. This is not my order. Mr. Flanagan, when you do mine, and I know you didn't do this one, don't do this. Y'all just put whatever, somebody just put whatever numbers they wanted to put in these spaces. I have never fined a person $370 as long as I've ever been on this docket. I'm sorry, on the bench, period. I have never fined anyone $370. Never. So and then I don't even know what this other $200 is. I have no idea. So this is what I'm going to have to do, Mr. Samuel. You're going to get, but again, see, this is how I'll be doing too much. I signed it, so I signed it. It was probably, I didn't pay attention. I didn't pay attention when I signed it to the actual numbers. And so I got to pay closer attention. So what we're going to do, I'm going to go back and look at my actual notes that I wrote about your fines and costs. And if I don't have them, they're at the court and I'm not at the court today. So I'll have to look at my actual notes about what your fines and costs and fees should be. And then at the minimum, you're going to get, let me see, hold on, 420 minus 315, 105, and then 315 divided by 2, 157. At a minimum, you're going to get back $262.50 at a minimum. But I think we may owe you some more money. I have to look at it. Okay. So at a minimum, we're going to refund to you $262.50. But I'll look at my notes and make sure exactly how much you're supposed to get back. Make sure we have your current address and phone number. We're going to mail you a copy of the discharge order. And then within about 4 weeks, you should receive a check or a voucher or some kind of something from us refunding you your money back. If you don't get that in 4 weeks, you can contact my clerk or your lawyer, and we'll look into why you haven't gotten it yet. Okay.
All right.
All right. You're all set. Have a great day. Stay safe.
All right. Thank you.
Whoops. Thank you, Your Honor.
You're welcome. And then I'm ready on Ross Springer, and I'm going to bring in Mr. Cunningham again. Just hopefully he's dressed. Mr. Ross Springer, start your camera. Mr. Cunningham, accept to join the breakout room and wait for the lawyer to come in to speak with you. I didn't finish asking Mr. Cunningham because he didn't have on a shirt. So whoever goes in there to speak with him, I want to know why he was 2 hours late for court. Mr. Ross Springer, we're ready for you. This is case number 194446401, the people versus Deontay Lamar Ross Springer. The defendant is charged with 1 count of operating while visibly impaired. Today is a date set for review. Appearance, please.
Just me. Good morning, Your Honor. Kashava Kirkland on behalf of Mr. Ross Springer. Mr. Ross Springer, please unmute yourself and state your name for the record.
Unmute, Mr. Ross Springer. Unmute.
Deontay Ross Springer.
Okay, yes. Yeah, Miss Kirkland, Miss Ritter, she doesn't put her appearance on the record unless the people in trouble. Like, but she don't want to show up for the review. Look at her. Don't want to show up for the review. She just want to show up when she's trying to put the hammer down on somebody. All right. Today is a date set for review. Mr. Ross Springer, you're off to a good start. You're off to a great start. You were placed on probation by me in August of last year. Mm-hmm. Today is your first review. You've done quite a bit. You have done quite a bit. And so you're off to a great start. So keep up that great work. You do have some things to finish. So you still need to complete the alcohol highway safety, the victim impact panel. You haven't had any positive, so I don't know why they put that on there, but okay. And then you do have a traffic balance of $962. And you apparently, I think, they put on here that you had to clear up a warrant in another jurisdiction, but they didn't say what jurisdiction. So you need to talk to Miss McCall to make sure of if she didn't put any jurisdiction on here. So that's usually they'll put a jurisdiction on there, but just make sure you ask your probation officer if she's aware of a warrant that you have in another jurisdiction. Okay.
Yeah, that's weird. I haven't had any police contact in a while. Yeah, like literally a while since,
Okay. Well, just make sure that there's nothing floating out there that's old. Okay.
Okay.
You have a balance of $962 in traffic tickets here at the court. So I do need you to try to get on a payment plan. You don't have to pay it in full. You could get on a payment plan, but you have to do that through the collections office, and I think they'll need, let me tell you, $240 for you to get on a payment plan for the 9. Okay.
Okay.
But you're doing a great job. Miss Kirkland, how long do you think he will need to finish the rest? Now he's scheduled, I put him on 14 months. So he has quite a while. I could give him like a 12-month review or 10-month review. We could bring him back in July if that's enough time.
Yes, please, July.
Okay. So let's bring him back in July. What about July What about July 23rd? Is that a good day?
That works for defense.
All right, so July 23rd. Now, if you're finished at that time with all these things, the what you have remaining, then I will discharge you from probation. So let's put them at 10 o'clock on July 23rd. All right, anything further?
No, Your Honor, thank you.
You're welcome. All right, keep up the good work, Mr. Ross Springer.
Thank you, Judge.
All right, have a great day. Stay safe.
You guys have a great one too. Be blessed.
Did you see, Mr. Ross Springer, did you see Miss Gibson waving at you?
No, I didn't, but I say hey to her every time I do come do my drops though. I see her right there every time. It's right by the probation.
That's my friend right there. That's my friend right there.
Hey, Miss Stevenson, how you doing?
Hey, Mr. Springer.
Now, Mr. Ross Springer, you see, she said, that's my friend. She okay, so remember
Miss Stevenson and Miss McCall are real. Look, they some good ones in there. Y'all keep them for real.
Oh, yeah. Oh, yeah. I don't think nothing gonna take Miss Stevenson from here.
Okay, yeah, y'all don't lose her. She a good one for real.
All right.
All right, have a good one. No,
All right.
Appreciate it.
Okay. I want him to pay attention to the use of your words. So when his case is over, he gonna be talking about, hey, friend.
That's my friend. I like him.
Friendships come with responsibilities, Miss Stevens.
That's true. That's true.
All right, let me pull up. Let me pull this up. Hold on, because it's from before. I don't have anybody waiting in the courtroom today for an order, do I?
No, Your Honor.
Okay. Oh, where am I? I'm spelling it wrong. I keep putting stuff in. Yeah. Oh. All right, this is case number 224436701. The people of the state of Michigan versus Sherry Lee Carnarvon. Defendant is charged with 1 count of gambling, disassociated person. Today is the date set for review. Appearances, please.
Janice Stevenson on behalf of Ms. Sherry Carnarvon. Ms. Carnarvon, ma'am, please unmute and say your full name.
Sherry Lee Carnarvon.
Today is the date set for review. Ms. Stevenson, I don't know. What are we doing?
Your Honor, I'm going to ask that this matter be closed out today and that
Why?
the matter. So,
what review do you have that I don't have?
So Ms. Carnarvon has tendered to the probation department proof of counseling. I did send that to Ms. Lurst.
Mr. Flanagan, can you call Ms. Lurst? I don't have an update that says that. I don't have any update that says that.
That's with regard to the counseling, Your Honor, and with regard to the Gamblers Anonymous. The only proof that Ms. Carnarvon has been able to get is she took a picture, a screenshot of herself at the GA meeting. I don't want to forward that to the court. She knows now she wasn't supposed to be doing that. So that she's gone to GA as well, Gamblers Anonymous as well, Your Honor.
I mean, Ms. Stevens, you know how easy it is to request from the person doing the Gamblers Anonymous session. Do you know how easy it is to request that they give you a proof that you have attended the sessions? Like you could literally chat the person running the meeting and say, I'm here court ordered and I need a receipt. Like literally, you could do that. Because at this point, you're saying, Judge, I want you to just take her word for it that she went. That's what you're saying.
Well, no, I'm not saying that. I am happy. I just don't want to forward the picture.
Well, I don't want the picture because the picture isn't proof of anything except that she zoomed into some meeting, took a picture, right?
Yes.
So the picture is proof that she zoomed into a meeting and took a picture. The picture isn't proof that she stayed at the meeting or that I don't understand why this has been so difficult for Ms. Carnarvon. And it's not been difficult for other people that I have assigned this very same thing. The probation officers, they haven't said, Judge, we're running into problems because this, that, and the other. And then if they are running into the problems, we solve the problem together. I don't know why this is going on with Ms. Carnarvon. I don't know, but a picture of the screen is unacceptable. And I don't know. How long has she been on probation? And then why didn't she come last time?
Ms. Carnarvon was ill at her last hearing, Your Honor. I spoke with her about an hour after the docket concluded.
And she was ill in the hospital, and that's why she didn't text you beforehand and say, Ms. Stevenson, can you request an adjournment?
She was actually ill in the bathroom, Your Honor.
And she couldn't text you and say, Ms. Stevenson, can you request an adjournment because I'm not going to log into court today?
No, Your Honor.
Okay.
I did call Ms. Carnarvon, and that's the information, or I texted her, and that's the response that I got. And then I spoke with her.
I want to know in what world that seems appropriate. I don't know. People just say, I'm not going today. They'll let me come back next week. I'm going to stop doing that too. I'm going to stop. I'm going to stop that 9:05 stuff, 10:05. Good morning, Ms. Lurs. There you go. Good morning, Ms. Lurs. Go ahead and unmute yourself for me.
Thank you. Good morning, Your Honor. Good morning,
Ms.
Attorney Stevenson.
Good morning.
Ms. Lurs, did
Yes,
you
Your Honor.
Ms. Stevenson says she sent you some proof or something for counseling for Ms. Carnarvon. Did you receive it?
I did receive the proof for the counseling, Your Honor. I did not receive the confirmation of the Gamblers Anonymous attendance, but Ms. Stevenson said that she had seen that. So I
don't go by that, Ms. Lurs. I don't go by that. Ms. Lurs, I have another question for you though.
Yes, Your Honor.
Do you have any other cases with me where I've sent somebody to Gamblers Anonymous?
I have not, Your Honor.
Oh, okay. All right. I was going to ask you something else, but
I do have a PSI SAE that I'm doing on somebody that I'm referring to Gamblers Counseling, if that was what you were interested in.
No. I was interested in something else, but
okay.
Let me ask you this question. When you received the information from Ms. Stevenson with respect to the Gamblers Counseling, were you satisfied with it? I don't know. Do we have approved counselors or do we just let them go anywhere?
There are counselors that we use. I was satisfied with the counseling, but I was really interested in getting the proof of the Gamblers Anonymous as well.
Me too. So this is what I'm going to do because I'm not satisfied. And I know I don't have this issue. I'm not having this issue on my other cases. So Ms. Lurs, if you could maybe consult find out from one of your colleagues, and maybe it's, I think maybe many of these are, I think Ms. Tucker has some where they're not non-reporting. I think Ms. Tucker might have some where it's reporting, because I want to know what proof are we getting for the Gamblers Anonymous, because I'm only having this problem with Ms. Carnarvon's case.
There should be the sign-in sheet that we give out, Your Honor, for when they attend the meetings.
I know, that's what I'm saying. That I knew it. So that's what I'm saying. We give them a sheet. They get the people to sign it. However, they could, I don't know, or the people could send them an email, right, Ms. Stevens? Like there are ways to confirm your attendance. The people at the place, if it's virtual, and I can't submit my sign-in sheet to you virtually, like they don't have the ability to sign like I do on my computer, they could send her an email. They could send her something at the saying she attended. I can't. Yeah, and then I was taking. Let me tell you this also. I was taking the gamblers cases a little lighter lighter than I've decided that I'm going to take them, and that I'm not going to do anything in terms of necessarily changing my sentencing. But the fact that this is a 1-year misdemeanor, and I've been thinking all along it was a 93-day misdemeanor, and it's actually a 1-year misdemeanor, she's going to do that Gamblers Anonymous, or we're going to do something else. And we're going to get the sign-in sheet from Ms. Lurst, and she's going to get proof, however many sessions I told her to do, she's going to get proof that she's done that many sessions. So number one, it's anonymous. Do not ever take a picture of the screen. It's Gamblers Anonymous. So don't ever take a picture of the screen. Number two, Ms. Lurst is going to get you that sign-in sheet if you don't have it, and then you're going to have to get it to the person that's in charge of the Gamblers Anonymous. Or they're going to have to send an email to Ms. Lurst every time you go saying she was here in attendance today. Like, okay. So that's what we're going to have to do, because I'm not going to take her word for it that she went to Gamblers Anonymous.
And certainly, Judge, we're not asking you to do that. I had another very similar problem, and the only proof that I don't know if we ever got to the place of tendering this to the court or not, but my client had to get like her phone records to show when she zoomed in, because whoever the video facilitator was, because of the anonymous nature of the meeting, would not indicate that she had been there. And so the only thing that we had was her phone records.
That's because she did not. No, that's not that's because she did not tell the people that it's court ordered. It's anonymous unless it's court ordered. And so she has to sign the waiver or whatever they want. She has to show them her probation order that says you must attend this. And I think I remember that client, and eventually I said I didn't get the phone records because I thought that was a lot to go through, and I said I was going to give a pass. And I think that's also the one where I told Mr. Farmer, under no circumstances can a person call into Gamblers Anonymous or any kind of anonymous. You cannot call into anything that is court ordered because there must be proof of your attendance. So the anonymous nature of the meetings has never, in my 17 years on the bench, they have never stopped us from getting records. But it's not happening until this virtual stuff that you all think I'm going to.
Right.
And when I say you all, I don't mean necessarily you, Ms. Stevenson. It's virtual, so people think I'm going to bend and say, oh, okay, no. Then Ms. Carnarvon may have to go in person with that sheet. So
okay.
It's okay, right. Exactly. That's good. So listen, the fact that it's anonymous is anonymous to everybody else except me ordering somebody to go. And once it's
I guess what we could just do is maybe they have to stop doing it. I mean, I understand, and I don't know if it's because I'm doing like other stuff to try to get the proof. My clients are having a very difficult time getting anything in writing from the facilitator. So
But
I
here's
think
the
maybe
thing.
the solution is to just stop doing the
Are they
virtual.
talking to their probation officers?
So most of them have been non-reporting.
Okay, well, we're gonna stop that. So then that's
Okay.
what's gonna be. We're gonna stop.
That would help me.
That's gonna stop the non-reporting.
Okay.
And they're gonna report and get that proof because I'm not doing that.
Okay.
All right. So and then the next time Miss Carnarvon is sick, she need to let you know because I'm gonna KPS her. I'm gonna put a warrant out for her arrest. You cannot be sick and don't tell your lawyer I'm not coming to court. Communication. That's simple. I'm sick. Can you get an adjournment? There's no place else. Courts in the world. If it was in person and she failed to appear, we're issuing a KPS. We're issuing a warrant. Like, why didn't she come? It's a warrant for her arrest. You can't just not show up. This is not a doctor's appointment. This is not, this is not an appointment at the hairstylist. You can't just not show up. You have to communicate with your lawyer, with the court, with your probation officer. There's 3 opportunities for you to let us know what's going on so that we don't do. But yeah, okay, let's go. So we're gonna. How many sessions did I order her to?
You ordered her monthly, Your Honor, and she was put on probation. It was I believe it was a delayed sentence.
So was it 12-month delayed sentence?
I'm looking, Your Honor. Yes, it was, Your Honor.
So I need at least, she would have been eligible for early discharge at 6 months. I need at least 6 sessions of the Gamblers Anonymous. If I ordered it monthly, that means she was supposed to go at least 6 times.
Your Honor, I apologize. It was 9 months delayed sentence.
Okay, so then I need at least, what's half of 9? 4.5. So I need at least 4 sessions. I need at least 4 sessions of the Gamblers Anonymous, of provable Gamblers Anonymous. So that might mean she had to go in person and get them to sign her sheet like we've been doing for years, or ask them for an email. But it's not anonymous to the court. I mean, I've never heard anybody say they won't give them the proof because it's anonymous. No, it's court ordered. It's court ordered. It's court ordered. Okay. So that means this is January. No, yes, this is January, March, April, May. We're gonna have to come back in May. I mean, well, I guess I'll count that one. I guess. Let's black out the other person's name, or the other people that's on there. Let's black their names out and give that proof to Miss Lurst. Miss Lurst is only entitled to see Miss Carnarvon. So I guess I'll accept that one. And then we need 3 more. And when did I originally put Miss Carnarvon on probation for?
April 20th, Your Honor, of last year.
We're not in the 12 months. We're still within the 12 months. Okay, so let's see. This is February, March, April. Okay, we could come back. She could still come back within her 12 months and get the delayed sentence. So if she gives me 3 more sessions, provable to Miss Lurst, I will still discharge her within the 12 months so she could get the delayed sentence. So let's come back April the what date did I put her on? What would make it within the 12 months? What's her actual sentencing date?
It was April 20th, Your Honor.
Thank you. So I'm going to bring her back April 19th. In order to get the delayed sentence, she has to give me 3 more sessions by April 19th. And here's the thing. She doesn't have to wait once a month. She could do them once a week, or if she wants to get it finished earlier, she could do once a week. You know, I just need 3 separate sessions of the Gamblers Anonymous. That's not anonymous to the court because it's court ordered. It's court ordered. And
Your
then
Honor.
maybe we can think about doing something else. Ms. Lurs, maybe I'll talk to you all in probation and see if the Gamblers Counseling is sufficient versus also Gamblers Anonymous. Well, I guess I would have to also talk to the Assistant Attorney General because I think they want, I think they always recommend the Gamblers Anonymous. Yes, Ms. Lurs?
If Ms. Carnarvon, I'm sorry, does get those 3 sessions done before the April date, do you want me to reach out and schedule a review, or would I just submit?
You can just, well, if she gets them done before then, you could let Ms. Stevenson know, and then we could try, if I have space to get her on the docket, I can.
Okay, thank you.
All right. Anything further?
Could Ms. Lurs, can I have your extension? I'm texting Ms. Carnarvon right now. So Ms. Carnarvon, I need you to call Ms. Lurs right away.
Okay.
It's 313-965-3418.
Cool.
Okay.
All right. I
Thank
just
you.
sent that to Ms. Carnarvon. You are all set. I don't have anything further for the record, Your Honor.
Okay, then we're all set until April the 19th. Have a great day. Stay safe.
Thank you, Your Honor. You too.
All right. Ms. Ritter, do you know who this person is in the breakout? I'm sorry, not the breakout room. In the waiting room. That's not on my docket. Ms. Ritter, are you there? She not there. She thought she left because she felt like we weren't doing her case. Ms. Ritter. Miss Ritter.
I'm here to well, I'm back.
You just got back. You just got back. Do you know who this is in the waiting room? Well, not this one name person, but this person with a full name. Do you know who that is?
No, I saw that earlier, Judge. I didn't see him on my list, though.
Oh, you saw this earlier? Because I just saw him.
Mr. Wagner, yeah, I saw him earlier.
Okay, and then of course we couldn't possibly know who the other person is. All right. Mr. Cunningham, start your camera. This is case number 234536002. People versus Demario Cunningham. Defendant is charged with retail fraud. And case number 224574702. Defendant is charged with larceny. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Kashaba Kirkland on behalf of Mr. Cunningham, P84015. Mr. Cunningham, please unmute yourself and state your name for the record.
My name is Demario Cunningham.
Ms. Kirkland, why was your client so late for court?
Your Honor, Mr. Cunningham he I guess did not write the date down wrong. He thought it was tomorrow. He stated he called the court today and was told that it was today, and he zoomed in immediately after calling the court. And he is apologetic. He does know I have had conversations with him. He's going to listen very closely to his next court date, and he was going to be early to the next hearing.
Do you all know that I never believe a person who says they thought it was tomorrow? Because if you truly thought it was tomorrow, why did you call today? Well, if you thought your court date was tomorrow, then why you call the court today? But I don't even want to answer to that question. I'm just saying, I never believe a person who says that. No, you were just late today. And in the future, if you're 2 hours late for court, it's a good chance you won't get your case heard if we are in trial or something. So I don't have a problem. But if I think something is tomorrow, I'm not calling. I'm not calling today. So anyway, with respect to the 2 pretrial conferences, how are we proceeding?
Your Honor, defense will move for dismissal in the absence of the two complainants.
Ms. Ritter.
So, Your Honor, with respect to case number ending in 360, the complainant witness is a corporate complainant witness, Family Dollar. The people have not seen a representative on behalf of Family Dollar appear for the pretrial conference. So at this time, Your Honor, the people will not be able to proceed with respect to that case.
You said the one ended in 360?
Yes, Your Honor.
Retail fraud. Okay, 360. Okay.
And then with respect to case number ending in 747, Your Honor, there is a civilian complainant witness, Mr. Alfredo Estrada.
Mr. Cunningham, can you please stabilize your device? You got me looking up in the ceiling. You real close to the camera. That almost, it's okay. I'm not gonna address it, but you real close to this camera. Miss Ritter, go ahead.
Thank you, Your Honor. With respect to case number ending in 747, that is a civilian complainant witness, Mr. Alfredo Estrada, and I have not seen Mr. Estrada appear for today's pretrial conference. So at this time, Your Honor, the people are asking for an adjourned pretrial conference to give Mr. Estrada one more opportunity to appear.
With respect to the case ending in 360, today is the day set for pretrial conference. The corporate complainant has failed to appear. The people have no explanation for that failure. They are unable to proceed. I am going to grant defense counsel's motion to dismiss. With respect to the case ending in 747, the court is going to deny defense counsel's motion and grant the people's request for an adjournment, giving them an opportunity to locate and notify that complaining witness of the obligation that they appear before the court. I'm going to set the final strike that, not final. I'm going to set an adjourned pretrial conference for Monday, February 26th. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. The bond will continue as to case ending in 747 with no contact with the complaining witness. With respect to the case ending in 360, Mr. Cunningham, we're going to mail you a copy of the order of dismissal for your records, okay? Anything further?
No, thank you, Judge.
Two things from defense, Your Honor. Is that hearing on the 26th at 8:36?
Yes, I'm sorry.
Okay.
Yes. Mm-hmm.
And second, Your Honor, permission to address bond.
You may.
Thank you. Currently, Mr. Cunningham is on GPS tether house arrest.
Really?
Yes, he remembers at his arraignment that he was put GPS.
Don't even worry about it.
Ms.
Ritter.
Actually, the people are going to ask the court to keep the GPS tether on in this matter. It looks like Mr. Cunningham has numerous larceny misdemeanor charges that are coming up in this courtroom. So due to the criminal history, Judge, we're going to ask for the court to not remove the GPS tether at this time.
But what about, certainly you're not objected to removal of some house arrest.
Oh, I thought it was for the tether. Judge, as far as the house arrest, what are the hours for the house arrest?
No, it's no hours, ma'am. It's house arrest. You're stuck in the house.
Well, Judge, I asked the court to amend that to curfew. If Mr. Cunningham has a job, the people are amenable to having those hours set for his job. But other than that, Judge, I'm asking the court to amend the house arrest to a curfew.
Mr. Flanagan, does Mr. Cunningham have another court date? For me, that should have. Okay. Does he have another court date for me on some larceny cases?
Yes, Your Honor. 3 more. You see. Actually scheduled for pretrial tomorrow.
Tomorrow. Okay. Who separated these cases like this?
Yep, on tomorrow.
Okay. Well, I can't do nothing about that because the complainants would be required to come tomorrow. Okay, well, counsel, you talked to me. I interrupted you. Then the people object to the removal of the tether. Did you want to finish saying what you were saying?
Yes, Your Honor. Thank you. So Mr. Cunningham remembers from his arraignment that he was placed on GPS tether with no curfew. When he got to the tether agency, they told him he was on house arrest. He's been on house arrest for 2 months since November, since Thanksgiving. These are non-assaultive charges. I understand that there are numerous larceny charges, but they are non-assaultive. He was working, so he's not currently working because he's been on house arrest for two months, but he was working at a plant called Sedecia, and he did lose that job because of this. He is trying to find another job. He is living with his mother and responsible for paying a portion of the bills. He's been unable to work with being on house arrest. So we are asking for removal of the tether. I don't believe it's necessary to protect the public or to assure his appearance in court. Although late, he did appear today. So we asked for removal of the tether altogether. If not removal of the tether, we just ask for any restrictions, that it just be regular GPS tether.
Okay. So look, now I'm gonna take it back. When I said, remember I said I didn't believe him when he said he thought it was tomorrow.
Yes.
So he does have court tomorrow. So now I take it back, Mr. Cunningham. See how I admitted I was wrong? I take it back because he does have court tomorrow, which I don't understand why anybody would have split his court dates like this. So you do have court tomorrow, so come back tomorrow. I'm going to remove the house arrest. Absolutely. I'm going to give a curfew right now. So right now, I'm not going to remove the GPS tether, but tomorrow, let's address his bond again, because depending on, the complaining witnesses and the situation with that. So I will remove the curfew today. I'm sorry. I'll remove the house arrest today. There's no house arrest. And then I will set a curfew for 11:59 p.m. to 5 a.m. So he has to be in the house between 12 and 5 a.m. And then we'll address it again tomorrow, depending on what happens with the 3. Are they larceny cases?
They are all larceny cases, Judge.
Okay. So we'll see what happens tomorrow with the larceny cases, and then we can readdress bond depending on what happens. Okay.
Thank you, Your Honor.
All right. Be on time tomorrow, Mr. Cunningham. It's at 8:30. Okay.
Yes, Your Honor.
All right. Okay. All right. Then we're all set. Have a great day and stay safe. Okay.
Excuse me, I have a question.
I'm sorry. Say that again.
Excuse me, I have a question.
Oh, yes, sir.
So, I'm not on house arrest anymore, right?
Well, you currently are, but we're getting ready to fax over an order to the tether unit. So you shouldn't get violated if you leave the house. Okay.
Okay. So what's my hours out now?
11:59 p.m. Right at, like, how Cinderella was gonna turn into a pumpkin at midnight.
Yes.
You too. You gotta be in the house by midnight. Okay.
Okay. So just
and
be
then
home.
you could leave again at 5 o'clock in the morning.
Okay. So just be home at 12.
Yeah. Yes.
Okay.
All right. All right. You're all set.
Okay.